Oh, hey there folks, Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, how does life insurance come into play in estate planning and elder law? Folks, oftentimes from my experience, life insurance is a great asset to have because if someone passes away, it's almost immediate liquid funds to cover expenses of the estate. The expenses of the estate, folks, could be the estate death tax or estate administrative expenses oftentimes that will be incurred when a loved one passes away. Could be the estate death tax, could be legal fees, could be the tax man, could be financial creditors and predators, which is a third-headed monster, or it could be a nursing home or Medicaid lien when that person passes away. Also, it could be probate fees and things of that nature. So that life insurance could be almost immediate liquid cash funds to cover taxes and other standard rudimentary estate administrative expenses, okay? Really, really helpful to have. And folks, oftentimes from my experience, folks typically purchase life insurance when their loved ones are minors, because the whole impetus and theory behind life insurance is if something happens to mom and dad before their time unexpectedly, you want that life insurance money there for the benefit of the surviving spouse, as well as the minor or maybe disabled, incapacitated beneficiary, which could be a minor as well. So that part of it, folks, if life insurance is an important part of your estate plan, and it very well may be after you have your state elder law attorney assess that situation, and if you have a beneficiary who's either a minor or a disabled person, folks, really, really important to have a third-party special needs trust created within your plan. That way, that minor or that disabled person can receive their life insurance proceeds not in the palm of their hands that would be exposed to their financial creditors and predators, which is a third-headed monster, and also put them over asset on their means-tested public benefits. Really, really important to have the beneficiary of that life insurance for a special needs person be payable to their third-party special needs trust. My recommendation from my experience, always much favorable and preferable for you, the consumer, to have those proceeds payable to a third-party special needs trust. Why, folks? Because there is no government payback typically on a third-party special needs trust, whereas a first-party special needs trust, there is government payback required. So devil's in the details there, folks. And of course, if you have a non-disabled person, but they're a minor or maybe a spendthrift, then that is also third-headed monster, financial creditors and predators. Important for your estate elder law attorney to create what I call family bloodline protection trust within your trust. That way you're giving your loved one better than a gift, you're giving them a protected gift. So there you have it, folks. Life insurance is great to have in your estate, but work with a qualified estate elder law attorney. And if you have a taxable estate for the second-headed monster, talk to your attorney about possibly creating an irrevocable life insurance trust, because if that is created within the required time period, that can remove the value of that life insurance from your estate, so it is not added or calculated to the gross value of your estate for the estate death tax. Folks, hopefully you found this educational video helpful. If so, please scroll down, post a comment, post a question, subscribe, follow us, and if you'd like to learn more, pick up a copy of my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Folks, thanks for joining us here today at elderlawcare.com.